Judge, this is Tommy Allen. Case number for the record is 23 CF 343. On Mr. Allen's case, the state has proposed putting Mr. Allen in the PTI program, but they're going to need some time to write the paperwork up. What we would propose is pass it to next, I think you have a court date next Tuesday?
I do.
Pass it to that date, and then by then we should have the paperwork together.
Very good. We'll continue to 3/21.
And that's at 9 o'clock, Judge?
9 o'clock.
Okay. Next Tuesday at 9 o'clock. Okay. No.
Donald Allen Alloway.
Charles Russell, Public Defender's Office. Mr. Alloway is present and approaching. His case number is 23 CF 242. The state has filed an information. At this time, defense is going to enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
Very good. Court will enter a not guilty plea, and we'll come back on 4/10, April 10th, 9 a.m. for pre-trial. Okay?
Good luck with the next one, Judge.
Al-Fakar.
Angelo.
Was that just a guess, or did you?
No, I think that's right.
Alofuokha.
Nobody will know.
Judge, can we pass him for a second? I don't get any response.
Brandon Ball.
Brandon Ball. No response. Can we pass him, Judge?
Donnie Bray.
Donnie Bray. B-R-A-Y. No response, Judge.
Shakia Brown.
Shakia Brown. Ms. Brown? Charles Russell, Public Defender's Office. Ms. Brown is present and approaching. Case number is 23 CF 259. At this time, the state has filed any information. At this time, we're going to enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
Very good. The court will enter not guilty plea and come back on 4/10, 9 a.m. Jerry Cabala.
Charles Russell, Public Defender's Office. Mr. Cavallo is present and approaching. Case number is 23 CF 293. State has filed an information. At this time, we're going to enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
Very good. The court will enter a not guilty plea. We'll come back for pretrial on 4/10. 9 a.m. Javier Kane Fuller. No turn. Would the state announce the case?
Yes, Your Honor. This is 23 CF 316. The state has filed a one-count information alleging carrying concealed firearm. And the state does have an offer for him, but it includes 24 months of probation. I don't know if he's prepared to take that today or if he would like to speak to a lawyer.
You do have a right to have an attorney appointed. You cannot afford one will be appointed for you. Do you have an attorney appointed here today?
No, sir.
No?
No, sir.
What do you want to do?
Whatever, honestly, whatever you...
Are you wanting to accept the state's plea offer?
Was it 24 months of what again?
Probation.
I don't want to, but I will, yes, sir.
I'd feel more comfortable if you spoke with an attorney. I'm going to appoint you a public defender. We'll come back on 4/10. The state will keep their offer open,
That's correct, Judge.
and after consultation, if you believe it's in your best interest, you can enter the plea at that time, okay?
Yes, sir.
Okay, thank you. Cheyenne Shambles. Appreciate it. Would the state announce Ms. Shambles this case?
Yes, Your Honor. Ms. Shambles, there was case number 23-217. She's been filing, information has been filed, a single count of child neglect.
Ma'am, you do have a right to an attorney with this new charge. If you wish to have an attorney appointed, you're going to hire private counsel.
No, I'd like to say that I was arrested under the wrong name.
Okay, what's your proper name?
Cheyenne Centeno.
How do you spell that?
C-E-N-T.
Hold on, C-E-N.
T-E-N-O.
P-E-N-O. That's your last name?
That is my legal last name, yes, sir.
Cheyenne Centeno.
Yes, sir.
Okay. Very good, Ms. Centeno. You want to have an attorney appointed, or are you going to, what do you want to do here today? Today, the purpose of today's hearing is, this is called an arraignment. The purpose of today's hearing is to make a plea, not guilty or enter a plea agreement with him. If you have not had a chance to speak with an attorney, I might suggest that you accept an appointment of an attorney. You still have to fill out the forms.
Okay.
But I can appoint a public defender, enter a not guilty plea, so you have a chance to meet with them. We'll come back on pre-trial on 4/10, and you can speak with them in the interim, and then you can determine how you wish to proceed, okay?
Mr. Russell, sir.
And I don't know what we need to do as far as correcting that name. Ms. Boss, so what needs to be done as far as the name?
Your Honor, we've actually already charged it in the alternative, Chambliss and Centeno. So we've already charged it that way.
Okay. Pardon? Whatever I need to do to get the name right.
We'll follow up, Your Honor, make sure.
Okay, thank you. Preston Davis.
That's also mine. And Mr. Russell, I've already talked to Mr. Medina about this. So he's already working on this.
Charles Russell, Public Defender's Office. Judge, this is Preston Davis. Case number is 23 CF 199. State has filed an information. At this time, we're going to enter plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
Very good. The court will enter the not guilty plea, and we'll come back for pre-trial on 4/10.
Thank you, Your Honor.
Jeremiah Ford, this is Mr. Gates' case.
Yes, Your Honor. This Mr. Ford coming up. He and I have had some previous conversations. At this time, Your Honor, we're going to ask the court to enter a not guilty plea and continue, he's already set for April the 10th for pre-trial.
I'm sorry?
We're going to enter a not guilty plea, and he's already set for April the 10th, Your Honor.
Okay. Court will enter not guilty plea, and we'll come back on pre-trial on 4/10, on April 10th at 9 a.m. Tremel Gilbert.
Your Honor, Travis Gates on behalf of Mr. Gilbert. He and I met this morning. If we can actually have the court enter not guilty plea on his behalf, he's already scheduled for April the 10th. Sorry.
Say that again.
We're going to enter not guilty plea on his behalf. He's set for April the 10th, Your Honor.
Okay, very good. Court will enter a not guilty plea. Come back on April 10th. Clayton Glover. This is a no attorney case. The state announced.
Excuse me, Your Honor. Clayton Glover is here on 23 CF 222. He is charged in a one-count information of felony petty theft.
Mr. Mr. Glover, you do have a right to have an attorney appointed with this new charge. You wish to have an attorney appointed?
Yes, sir, please.
We'll appoint the public defender. The court's going to enter a not guilty plea. And you'll have to come back on 4/10. Make sure to meet up with your attorney before then. 4/10 at 9 a.m.
Yes, Your Honor, and if Mr. Glover can fill out that paperwork before he
Correct.
leaves the courtroom and turn it in downstairs,
That'd be
I have
great.
some paperwork I would like him to fill out too.
Okay. Robert Hall. Mr. Gates is yours. Robert Hall.
Yes, Your Honor. Mr. Hall and I met earlier. I will say that the state's offer, in Mr. Hall's case, is to a misdemeanor. He and I would like a little more opportunity to review that offer. If we can leave him, or not guilty plea today, and leave him separate, the 10.
Very good. Enter a not guilty plea, and we'll come back on pretrial on 4/10. No information's been filed.
I have one that was filed February 20th. State has charged him in 23 CF 315 possession of controlled substance, count 1, possession of paraphernalia, count 2. All I can say is I've got
Like, who's supposed to do that? So my question for today is, obviously this, we can get this corrected easily, but is this something that we can plead today if it hasn't been filed with the clerk, or?
Well, and I think if we just have the court take a copy of the information, the clerk will take that as well.
Okay, do we have an extra copy?
Do you have a copy?
I do not, we've gone paperless, Your Honor.
If the court will allow me to scratch out, I have a little notation here on mine regarding how many body camera videos there are.
Court will enter not guilty plea and come back on pretrial on 4/10.
Thank you, Your Honor.
Thank you very much.
Judge, Mr. Bray showed up. Mr. Bray showed up, number 8, if you want to call him.
Okay, hold on a sec.
Is he going to call him?
Donnie Bray.
Yes, sir. Charles Russell Public Defender's Office, this is Donnie Bray, case number is 23 CF 288. State has filed an information, will enter a plea of not guilty, request trial by jury, 15 days to file any plea recommendations.
Court will enter not guilty plea, come back pretrial on 4/10. Mr. Bray, you need to be here on time. You might end up getting picked up. Don't want to do that. Okay?
Sorry, Your Honor.
That's all right. Want you to not end up in
Your Honor, I
jail.
will say Mr. Bray actually was here at 9 o'clock, and I talked,
came in.
and he came back, so
Okay.
he was here earlier today.
Okay. Well, I just don't want you to get in trouble. Really.
Yes, sir. Thank you.
Okay. Okay. Next is William Hanson. This is no attorney file. State, would you announce?
Yes, Your Honor. William Christian Hansen is charged in 23 CF 223 with possession of a blank forged, stolen, fictitious, counterfeit, or unlawfully issued driver's license. The state's offer is pretrial intervention.
Mr. Hanson, would you like me to appoint an attorney so you can discuss this, or are you comfortable accepting? Do you know enough about pretrial intervention to accept that?
Yes, sir.
Yes, what? I gave you 2 alternatives. Are you want to take the pretrial intervention, or you wish to have an attorney appointed?
I already have an attorney.
Who is your attorney?
I forget his
Why isn't he here?
Sir,
It's not gonna help you very much if you don't have your attorney here, if you've hired one.
he's not fired.
I'm sorry?
He's not fired, I forgot his name.
Where is he? Your attorney should be with you when you come to court. I'm just asking you, where is he?
He's not here.
Okay. Okay. I'm gonna enter a not guilty plea. You need to come back here on 410, and when you come back here on 410, bring your attorney, and if you don't have your attorney here, make sure at least have his name or her name, okay?
Yes, sir.
But really, you need to tell your attorney that he needs to be here, and he'll know that because he's probably, when he finds out he wasn't here, he's probably glad you forgot his name. You didn't have to say it in open court. But 410 at 9 o'clock, okay?
Yes, sir.
We're entering a not guilty plea on your behalf. Thank you.
Thank you.
Rachel Harris. Would the state announce?
Your Honor, Rachel Lynn Harris is here on 23 CF 339. She's charged with 2 counts, 1 count of possession of controlled substance, 1 count of possession of paraphernalia.
Does the state wanting to place any offers out there, or where are we at?
Your Honor, we've gone paperless. I have to look up the offer real quick.
How's the paperless working?
I don't need those comments on the record, Your Honor.
I'm sorry, I need to cause a problem here.
It's problematic, is the nicest thing I can say, Your Honor.
Very
We're
good.
working on it.
The state's offer would be a plea to count 2, which is the possession of drug paraphernalia misdemeanor, adjudication of guilt and court costs only.
And what about count number 1?
Count number 1 would be dismissed.
So, Ms. Harris, you can do one of 2 things. You've got an offer on the table. If you wish, you also have the right to an attorney. If you wish to discuss this with your attorney, I can appoint the attorney, enter a not guilty plea, and come back on 410. What do you want to do here today?
Go ahead and do not guilty and
Okay. I assume this offer will still be on the table.
Absolutely, Your Honor.
So we're entering a not guilty plea. The court's going to appoint the public defender.
Thank you very much.
You need to fill out the form and hand it in today. Okay?
Yes, sir.
And meet up with your attorney between now and April 10th.
Yes, sir. Thank you very much.
Thank you. Robert Jelks.
Yes, Your Honor. Try this case on behalf of Mr. Jelks, Your Honor. We have a plea agreement to be filed in Mr. Jelks' case. It'll be a plea as charged.
This is case number 23 CF26.
Including the score sheet, no objection to the score sheet.
Thank you.
Your Honor, Mr. Jelks will be entering a plea no contest as charged. The recommendation and sentence is going to be a withhold adjudication based on 11 months, 29 days probation, concurrent in all 3 counts. $6.15 court costs, $150 offender fee, regular substance use evaluation for 30 days, any recommended treatment within 60 days, rating your analysis, 24 hours of community service work, and then I wanted to make sure 2 things. One, the supervision fee is waived, and we put on the record that we haven't had an opportunity to review the FTO report, but Mr. Jelks is entering the plea right now.
Very good. Is that the state's understanding of the agreement?
Yes, Judge.
Mr. Jelks, would you please raise your right hand, sir? You swear or affirm the information you're about to provide this court It's the truth, nothing but the truth, so help you God.
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see that those same terms are contained in the written plea agreement that you have signed. Is this your understanding, this is what your agreement is?
Yes, sir.
Okay. And you've had a chance to go over this plea and sentencing agreement in detail with your attorney? You've read this first?
Yes, sir.
And you've gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
And you understand that by entering this plea here today, you're waiving the right to go to a trial, and you're waiving some other rights as well, but you're doing it because this will be a final resolution of this case.
Yes, sir.
You believe it's in your best interest to do so?
I do, yes, sir.
Very good. Based upon that testimony, the court will accept your plea. There will be a withhold of adjudication on all 3 counts. The defendant is sentenced to 11 months, 29 days of probation. They'll all be served concurrent at the same time. There'll be a number of court costs and fees that are contained in this plea agreement. The substance abuse evaluation and recommended treatment within 30 and 60 days are important. Random UAs, etc. 24 hours of community service work. And we will waive all costs of supervision. Okay. Any questions?
No, sir.
Thank you.
Thank you.
Jakeem Scott. The state announced that case. Scott, Jakeem Scott.
I'm done. Yeah.
Your Honor, that's 23 CF385.
Mr. Scott is not here. State, I wish to.
Your Honor, state request case, please.
Court will issue a no bond case. We'll start with the inmates. Al Seitz, Claude Al Seitz.
Can we put the inmates in order, just? You call for, Sean Smalls?
Who's?
Shawana Smalls.
There's Shawana Smalls.
Nope, I missed that one, thank you. This was Shawana Smalls. No attorney, would the state announce this? 23 CF 375. State wish to make a request.
Your Honor. Is Mr. Smalls in custody?
No.
No, he's not in custody. Your Honor, the state will ask for a KPS.
It's a she, but yes, court will issue a KPS. So Al Seitz, I think.
Yes, outside.
Charles Russell, Public Defender's Office. Judge, this is Cloud Al-Qaidi. Case number is 23 CF 219. State has filed an information. This time will enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions.
Court will enter a not guilty plea. Come back for pretrial on 4/12, April 12th.
Yes, sir.
Sam Fergan.
We took care of him this morning.
You did that one this morning.
That's right, that's the one that did that. So then it should be Salvador Bertu.
Judge, if I could just have a moment. Judge, this is Salvador Bertubin. Case number is 23 CF 235. State has filed an information. At this time, we're going to enter a plea of not guilty. Request trial by jury and 15 days to filing pre-arraignment motions.
Very good. The court will enter a not guilty plea and will come back on 4/12 for pretrial.
Ronald Koch.
Couch?
Couch.
Couch. Hey, TJ, let's go ahead and call him.
Judge, this is Ron Couch. He has two cases on the docket, 23 CF 249 and 23 CF 255. State's made an offer to plead on his case, but I'll need to talk to him about it in the back. So if we could pass his case for a second, and then I'll bring him back.
Right?
And the same thing on Jarrett Dawson, who is next, and the same thing on Nicholas Ducati. Those three people I need to talk in the back.
Hey, JJ, we got to put Calvin Dawson in the category. They've got and Jenkins is announcing here, so those are the last. You want to, should I skip them?
You want to bring out Elliot?
Elliot was one he needs to talk to. Yeah, Elliot. Elliot, yep. Elliot. Right there.
All right, that's motion to no return.
The state announced this case.
I think all.
Yes, Your Honor.
William Ray Elliott.
This is 23 CF 338.
Okay. Mr. Elliott, you do have a right to appointment of an attorney in these matters. Do you wish to have an attorney appointed? Yes?
Well, I'd like to plead guilty. I'd like to plead guilty and
Is there an offer on the table?
There is, Your Honor, there is a DUI attached to this. So this is going to include 36 months of probation. He is going to lose his driver's license for 6 months. He's going to have to do multi-offender DUI school, the interlock for 1 year, a 10-day vehicle impound. I don't know if he understands those restrictions.
I understand,
Or
yes,
he
ma'am.
wants to speak to him.
Do you have something written down?
I do not, Judge. I have the offer sheet written up, but I do not have a written plea agreement.
Can you prepare one and bring it back?
I sure can, Judge.
I think he's, so long as this doesn't include jail time, I'm willing to accept his understanding of what's going on.
Drugs, DUI,
Yes, sir.
misdemeanor.
I can do
Just
that.
hang with us. We'll get it in writing, so, and I'll ask you a few questions, make sure you understand what you're doing. And then, if you still want to enter into the plea, we'll get that done today, okay?
very good. Thank you, sir.
Okay. Eraza Vasquez.
You want to take Mr. Oh, sorry. Yes, because that's
Is that for this one?
Who has Raza Vasquez?
Perfect timing.
Good afternoon, Your Honor.
Good afternoon.
Señor Erazo, hasta fuera, por favor. Iba, mira, acá fue.
Charles Russell, Public Defender's Office. This is Gerson Erazo Vasquez. Case number is 23 CF 280. State has filed an information. At this time, we're going to enter a plea of not guilty. Request trial by jury. 15 days to file any pre-arraignment motions.
Very good. The court will accept the plea of not guilty and will return on April 12th for pretrial. And in the meantime, the defendant will be able to meet with his attorney and figure out where this case is going. Does the defendant have any questions? No. Okay.
And
Thank
Your
you.
Honor,
Yes.
for his attorney's knowledge, there is a new case with an additional 2 victims that we're getting ready to file on as well.
We saw that, and I think it's set for the plea day next week or the week after.
The arraignment is set for 11, I believe.
Okay.
We'll take care of it.
Very good.
Irvin Westbrook. Next for Mr. Stewart.
Good afternoon, Your Honor.
Hold on a second here, let me.
I'm going in the back.
What number?
He was from the morning socket, I ran him back.
May it please the court, Your Honor, Brad Stewart, on behalf of Irving Westbrook, Judge. This is 20 CF 1034. Your Honor, if I may pause for a moment as Mr. Westbrook signs a plea to review written plea agreement.
Okay.
Your Honor, at this time, Mr. Westbrook is prepared to admit the violation of probation with the understanding there's going to be a modification in his existing probation to include 2 years of community control. There'll be $100 VOP fee, and he is to complete all original requirements. Your Honor, may I approach?
That is the state's agreement, Your Honor.
Thank you.
And Judge, since this is a modification, I don't believe we need to file
So,
for additional
just
scrutiny.
for clarification, when it says modify existing probation, is this continuing with the same term of probation? It's just that for the next 2 years, rather than being on regular probation, you're on community control? Is that, I want to make sure I'm understanding this.
That's correct, Your Honor.
State?
That is our intent, Your Honor.
Okay. Mr. Westbrooks, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, and you heard your attorney state the terms of the plea agreement, which I see is also contained in the written agreement that has your signature on it. Have you read this agreement, and have you gone over it in detail with your attorney?
Yes, sir.
And you understand that by entering this will be a final resolution of this violation of probation? You understand that?
Yes, sir.
You believe it's in your best interest to enter into this?
Yes, sir.
And the one thing I just want to make sure you understand, this is basically the same term of probation, but you're going on the next 2 years in community control. I don't like the term community control. I like the slang term better. House arrest. Okay? That's a better description.
Yes, sir.
And I just want, the reason why I'm saying it, because I want you to understand it. Because there's this process. See, we start off with criminal cases, they get a PTI, diversion, you get probation, and then you get community control, and then you get what?
Prison.
That's not where I want you to go. I want to be clear about that. But it's going to require you to pay attention to this.
Yes.
Because there's a lot of rules and regulations, a lot of checking in, a lot of this, a lot of that. You need to take it day by day so you don't end up here.
Yes, sir.
Okay? That's my speech for the day. Okay? The court will accept your plea, modify existing probation to include 2 years of community control. Fees and costs will be added. You must complete the original requirements as well. Okay? Thank you.
Your Honor, Angelo Okloosa was downstairs in the other courtroom, and he stated, you know, I'm going to take
Your Honor, may I be excused? May I be excused, Your Honor?
Thank you, Mr. Stewart. You have a good day. Mr. Okloosa?
Yes, sir.
Is he got the PD because he's in the attorney file?
What's that?
Does he have the PD?
Yes, Mr. Russell.
Your attorney's in the attorney file room, so we'll get
If you could have a seat, Mr. Russell, leave that out.
Your Honor, can you bring up Shawana Smalls one more time? You issued a capias.
Sure.
I noticed, so that's 23 CF 375 for the record. I noticed. Sure.
Yes, go ahead.
There was a not guilty plea which was entered just a few days ago.
By?
That was by
I've got a no attorney on this.
Attorney Charles George, it looks like, filed a notice of appearance and pleaded not guilty.
This is Smalls. It's, you want me to give you case number? Shawana Smalls.
We got it was filed today. Sorry, Your Honor, when I checked yesterday, there wasn't anything.
It's all right. Okay. So, not guilty, so we'll just set this, withdraw the capias, enter the not guilty as requested, well, it was done in writing, and we will come back on 4/10 for pretrial. Thank you, Mr. Rogers.
Frankie Gale.
Yes, Your Honor, this is Mr. Gale before the court. At this time, Your Honor, if we can actually enter a not guilty plea on Mr. Gale's case and move him to April the 12th.
Very good, the court will enter a not guilty plea on his behalf, and we'll come back for pretrial on April 12th, 9 a.m.
Well, I can get released?
Not today.
Well, I thought it was just a trespassing. Cause I wasn't loitering. I thought it was just a misdemeanor.
You're incorrect. This is felony charges. Your attorney can go over those charges with you.
Your Honor,
Burglary of
that's part of the issue. I'm asking the court to let me bring him back on the 12th. There's behind the scenes stuff that I'm working on.
Very good. Okay. Stay in contact with your attorney.
I'll come see you.
And act like I didn't hear that.
That would be Michael Jenkins. No, not Jenkins. John Skipton Jenkins. We're gonna go with Max Jones.
Max Jones. Did we do Garofalo already?
No, Your Honor, I think they skipped Ms.
Oh,
Carlson.
did we? I'm sorry. I'll get that.
That's all right. And Randall Florence too.
This is Mr. John before the court, Your Honor. We actually had a meeting yesterday where we went over a potential plea agreement. I explained to him the rights and all that. I was able to negotiate the plea agreement for him today. So he already knows the ins and outs of the plea agreement. I just need him to sign it, Your Honor.
Okay.
Your Honor, may I approach the state and I were discussing, of course, it sounds like he's going to score about 11 points total.
At 11.8, correct.
And I was letting Mr. John know that, okay? And Your Honor, I put on there, because it's leading to lesser included, I made sure for Madam Clerk to put the statute number on there as well, and abundance of caution, so that we had it. He'll be pleading no contest to lesser included offense of felony battery, as charged in count 2 and 3 of the information. If he adjudicated guilty, we're going to sentence him to 11 months, 29 days on count 1 and 2, concurrent with credit for all time served. Count 3, which is the secondary misdemeanor, will be sentenced to time served. Sets the standard court cost, 150 public offender fee, and he's asked for 24 months from the date of release to pay those costs. No probation to follow.
State?
That's the state's agreement, Your Honor.
Very good. Mr. John, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement.
Yes.
And I was reading along, and those same terms are contained in the written plea and sentencing agreement that you have signed. So my first question is, did you read this plea agreement?
Yes, sir.
And did you go over it in detail with your attorney?
Yes, sir.
And you understand that by entering this plea agreement, you're waiving some valuable rights. The big one is the right to go to a trial, make the state prove their case and all that.
Yes, sir. I
We're
understand.
doing that, waiving all that so you can resolve this case in toto today. You understand that?
Yes, sir.
And you believe it's in your best interest to do that here today?
Yes, sir, I do.
Very good. Based upon that testimony, the court will accept this plea agreement. There'll be an adjudication on all three counts. The lesser included count 1, which is felony battery, and as well as the other 2 as charged. Counts 1 and 2, the court will sentence the defendant to 11 months, 29 days in the county jail. They'll be served at the same time, concurrent, and you will get credit for all time served, okay? So, in addition to that, you've got, of course, the ever-present court costs and fees. You'll have 24 months to pay those from the day you get released before it gets sent to collection, okay? Question?
No, sir.
Thank you.
Thank you.
Judge, I've got a score sheet printed out downstairs. I'll provide it to you as soon as we catch the
Okay,
case.
thank you.
Sir? Sir? You need to get your fingerprints. Next will be Felicia Garofalo.
Because everybody's pushing, I'm going to say Garofalo, if I'm correct.
I'm sorry, Garofalo.
You know, this is Ms. Garofalo before the court and 23 CF 282. She also has 23 CF 433 that's scheduled for felony arraignment next week. At this time, I'd like to enter a not guilty plea on both cases.
What's the other case number?
23 CF 433.
So we'll enter not guilty plea on both of those cases.
Yes, sir.
We'll come back on 4/12, April 12th at 9 a.m.
Yes, sir.
Okay? For pre-trial.
And Mr. Davis is on that one too, yes.
Thank you.
So we're still waiting on that. Besides Mr. Kerr, is there anybody else in here that thinks they have a court today? What's your name?
Sonia Greco.
Sonia Greco.
She was from this morning.
This morning, but, she's a Mr.
Who is it?
Sonia Greco from this morning.
Yes, Your Honor. It would have been number 18 on the 9 a.m. docket, unrepresented.
Yes.
Come on up, Ms. Greco. Can you take those glasses off your head and put them right there on the left?
I think it's changed. I believe last one we did, and we'll get ready to go. Does the state have this case number? I'll be glad to call it out.
I'm looking it up right now, Your Honor.
It's case number 22 CF 2564, Greco, Greco. Ma'am, you've been charged with a violation of probation.
Yes.
Did you know the hearing was this morning? Did you know that?
I'm sorry?
Did you know that your hearing was at 9 o'clock this morning?
Yes, I had a seizure on the way to catch the bus, and when I caught the bus, they overlapped by 10 minutes, so I had to wait. They only have 3 buses that come out here during the day.
Okay.
So I called beforehand, they told me just that
Just
get
come on
here
up.
when I could.
Okay, we're here and we'll deal with it now.
Thank you.
So, ma'am, we're here just to take a plea here today, but you do have a right to an attorney with these new charges. You wish to have an attorney appointed?
Yes, please.
Okay, the court will appoint the public defender. You got to fill out some forms and turn it in today, but court will enter a denial, and we'll come back on we say April 11th
Okay.
at 9 o'clock. Okay, meet with your attorney in the interim. Did you get a card? You can give her a card, okay. Meet up with your attorney between now and then, okay?
And Your Honor, just for
And we'll withdraw the KGs. I'm sorry.
oh, just for the sake of the record, so that her attorney can hear it.
Mr. Morrow,
Early,
listen up on this. She's referring to this case. Go ahead.
is that the recommendation is a reinstatement with special condition to complete the Keaton program.
And the same word had said that before the
Okay.
meeting had even been signed.
Okay, well, if you have a chance to talk with her, today, but we'll come back on the 11th and if not today. Okay?
I think we may be rolling into the afternoon now, so if it's all right. I'll
Okay,
talk.
that's fine, whatever you think.
Thank you.
I'm sorry. We need to get this done.
I'll run and grab them, TJ.
I think this case is going to go kind of rush Mr. Alpha.
Okay, that's good. Mr. Russell. What did we do with Elliot? No attorney? What did we do?
Your Honor, I do have a written plea agreement drawn up. I don't know if they want to bring him out from the cell for him to look it over in Ella.
Is that the one that was, I can send it back here. Okay, paperwork for Elliot.
Your Honor, may I address one matter on Mr. Powell before we go into that hearing?
Sure.
Mr. Powell had submitted for the court's consideration a document. I don't know if the
Sorry,
court,
you lost me here, I'm sorry. What hearing are we talking about?
this is Ernest Powell set for sentencing at
Ernest
2:30.
Powell.
I'm sorry, Your Honor.
That's all right. There's an attorney Powell.
Oh, I'm sorry.
Attorney Powell, and I didn't know you were
Yes,
saying
Your Honor.
Powell, and I didn't know what you were talking about.
On Mr. Ernest Powell's sentencing matter this afternoon, he had submitted to the court a statement. I didn't know if the court had reviewed it. The state has stipulated the admissibility. If the court has not had an opportunity to review it, I have a copy. I was hoping to save some time in the
You can give
hearing.
it to me.
Okay, we'll run into this one out of SG, and then we'll go to the rest of whatever it is.
Okay, we've got half a dozen cases.
So we have one out of custody that he's going to handle real quick, so we can get him reunited with his child, and then we got the inmates all ready to go right after.
You ready?
Yeah, and then we'll be ready for our security,
Okay, good.
or our Nelson hearing. And then-
Yeah, I think the Nelson hearing is going after the 2:30.
Oh, is it? Okay.
Judge, this is Angelo, and he says you pronounce his last name Okloosa. Case number.
Whatever you say is what we call you.
Case
I'm sure
number.
that other people have had difficulty with your name as well.
Yes, sir.
Case number is going to be 23 CF 458. I didn't see any information.
And Your Honor, that's what I was about getting ready to address. The state is gonna send the, not take no action on the child abuse charge and send the DUI to county court. Your Honor, that paperwork is in transmission right now. I don't know if another CT case has been opened. If we want to keep this on next week's docket just as a status to make sure everything's fine and that the defendant will know what date to show back up for county court maybe, that might be helpful if we keep it on the 21st.
I mean, I'm fine with that.
Okay.
So hopefully you can figure out where he's supposed to be going and
Yes.
been transferred. You understand what's going on?
I'm sorry, sir?
You understand what she's saying?
Oh, no, sir.
I'll explain it to the judge.
Okay.
That'll work. Thank you, Judge.
Thank you. Just talk to your attorney. Who's this?
This is Mr. Couch.
Mr. Russell, this is Mr. Couch. We'll call him back up.
Oh, I'm sorry, Judge. I've got to write the agreement back. I did talk to him in the back, and Mr. Dawson and Mr. Ducati, I talked to all three of them. Got to write up the agreements for all of them.
Okay, so we'll take a break and then we'll, okay. Who else do we have? Do we have anybody else other than? If not, we'll just take a break and come back and then we'll start our.
Brandon Ball. Page 2.
State on Mr. Ball, 23 CF 252.
Your Honor, the state's requesting a KPS. Mr. Ball's name has been called several times, and he's not.
Total issue of no bond cases. I think the rest are what about Mr. Elliott?
That I sent that written plea agreement back.
You want to see him?
Yeah.
We'll see Mr. Elliott.
And then, what about Mr. Gates, Randall Florence?
We entered a not guilty plea in his case, Your Honor.
Okay, very good. So for our 130, it's just those inmates that are working on their agreements. Okay. So Mr. Elliott, I'm going to swear you in here in just a second. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
I do, Your Honor.
Okay, now the state has provided you a written plea agreement. Have you had a chance to review that plea agreement?
I have, Your Honor.
Now, Mr. Elliott, this is a little tricky because right now you don't have legal counsel. Normally, we want you to be able to talk with an attorney, make sure you're comfortable, etc. However, I think the terms of your plea agreement are pretty straightforward, and if they included jail time, I'd make sure you had an attorney. I wouldn't accept your plea even if you wanted me to, without you talking to an attorney. But, so I'm open to accepting this plea here today. It would allow you to be released for one thing. But I want to make sure that you understand this plea agreement. Is there anything in this agreement that you have a question about?
One thing, Your Honor, on the court says, defendant will attend and successfully complete the following counseling as indicated, and it has an outpatient substance abuse check there. Would the court consider the residential substance abuse program as for I plan on checking into JADA immediately after my release?
I mean, if you're asking me whether an inpatient program would substitute for an outpatient program, the answer in general would be yes, but.
Sir, Jada is not a residential treatment facility, it is a halfway house.
I'm sorry, it's what?
It is, Jada is not a residential, it is a halfway house.
Okay, so that is not a residential. Okay.
Yeah, meaning it's a place, sorry, Judge, it's a place where he can go and stay, but I don't know if they'll provide him treatment. Then probation is indicating I'm correct about
Okay,
that.
so here's the thing. If I accept this plea, the way it's written, it says a substance abuse outpatient. Now, if it says substance abuse outpatient, that's a lower level of care than an inpatient, right, in general. So, what you're going to be for 3 years, you're going to be on probation, right?
Right.
So if probation would approve your substance abuse program, whether it be inpatient or outpatient, that's workable, right? You guys would do that?
Yes, sir.
You understand what I'm saying,
Yes, sir, Your Honor, I do.
In other words, you gotta get their approval, like this, you know, you say, hey, can I go to this program? Well, you think it's this program, but it's really not. It's not what you think it is. So they've got to approve it. But you're gonna be under their supervision, so it's not just with that, it's gonna be with the whole probationary period, you're gonna be under their supervision. They'll walk you through, well, you know, how often, your curfew, what you need to do, you know, your random UAs that they may require you to take. So. Okay. But we want you to get the help you need, and I mean, I'm hearing you voice that you want to do this too.
I have a strong desire to, sir.
Okay. But this is just the start.
Understood.
Now you got to do the day by day, the hard work. You'll have people that'll support you, but a lot of it's going to be right here.
Understood.
You got to have that want to in order to overcome this. But if do you have any other questions regarding what's in that?
Not that I can see at this moment, sir.
Okay. The state, why don't you go ahead and identify them?
Yes, Your Honor.
And read out and make sure for the court record.
So yes, Your Honor, to start, the court's already gone over that he's seen the written plea agreement. I think it'd be appropriate for the defendant to indicate whether or not he understands that he has not received the discovery in this case, and whether or not he wants to proceed without a lawyer. I think that'd be appropriate for him to indicate the answer to those questions on the record.
So normally you get a chance to look at discovery, what the state has, but you're essentially by entering this plea, be a final resolution, and you're waiving the right to get that. You understand?
I do understand that, sir.
And so, Your Honor, at this time, the state is willing, if the defendant pleads to counts 2, 3, 4, and 5, count 2 is possession of drug paraphernalia, count 3 is attaching a tag, not a sign, count 4 is an insurance violation, count 5 is a driving under the influence, second conviction more than 5 years after the prior conviction, which is an enhanced DUI, Your Honor. And in exchange for a plea to counts 2 through 5, the state would dismiss count 1, which is the felony count, so the defendant will be pleading to all misdemeanor counts. The state is requesting 36 months of probation from the court, 11 months and 29 days of probation on count 2, 11 months and 29 days of probation on count 5, 6 months probation on counts 3 and 4, so that's a consecutive 36 months of probation. The misdemeanor court cost would be assessed. The defendant would do a substance abuse evaluation within 30 days and begin any treatment within 60. He would do the required 50 hours of community service per the driving under the influence charge. He would pay the $1,000 fine that's required per the driving under the influence charge. His driver's license would be suspended for 6 months per the DUI charge. He is to maintain gainful employment or do 2 job applications a week. He has to attend and complete the victim impact panel per the DUI charge. Attend multi-offender DUI school, that's also mandatory. The 10-day vehicle impound, which is mandatory, and the 1-year interlock, which is mandatory, Your Honor.
Now, assuming we accept Is that your understanding of all that? You okay with that?
I understand, and I am, yes, sir.
Now, when you get out, you'll be able to get out today probably, I think. And you're gonna have to report to probation. And what they'll do is they'll walk you through not only what's in your agreement, but any other requirements, okay? So you're gonna get, we're not gonna just send you off and you not get anybody that's gonna be explaining this stuff to you. You need to follow up with that. You can follow up with probation first thing in the morning.
Yes, sir, not a problem. Will do.
And Your Honor, I see that court security is handing him a pen. I think I need to sign the agreement as
Okay.
well.
Very good. Did you put the mandatory court costs in there, Ms. Sharpless?
I did not, but I can.
What are
Your
those numbers, Madam Clerk? Is it 488? You have the entire term of the probation to pay all those things. Now, there's a lot of money involved.
Yes, sir.
Just, you know, you can, you can eat that elephant, eat it one bite at a time. You don't have to eat the whole elephant one time. So just, but don't wait until, month 30 to start paying on that, and then you're gonna be stuck and they'll be violating you, and that's not what you want.
Absolutely not.
Okay?
Thank you, Your Honor.
Very good. So the court will accept this and will order the 36 months of probation. Basically, they're consecutive, 1 year, 1 year, and 2 6 months, so total of 36, with the requirements, the most important which are the substance abuse evaluation and following through with the, whatever those requirements are, and then there's a number of fees and costs and other things that are contained in this plea agreement. Any questions?
None that I can think of, Your Honor. Thank you, sir.
Now, is he going to get contact information for probation?
Yeah, he's gonna hand us the stuff as soon as we bring, before we put it in the. Good.
Thank you. Are we ready with any of these other ones, Mr. Russell, or you want me to take a little break and we'll come back and then finish up with those?
Take a break, Judge.
Okay. Okay, we'll take about a 15-minute break and then we'll come back and.
All rise. Orders of recess.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100.
Michael Harrison.
Okay. We'll call Michael Harrison.
Ryan Morrow for Mr. Harrison, Your Honor. Except for the test hearing today, he is not before the court.
Your Honor, I've spoken with Ms. Keene from probation, who did remind him of his court date today. The state would ask for a habeas corpus.
And which docket is he on?
It's on the 2:30 afternoon docket.
On the 2:30?
It is number 3 on the 2:30 docket, Your Honor.
And he does have 2 matters, I believe.
Yes.
Gotcha. Very good. Court will issue a habeas on Michael Harrison.
And Your Honor, I have an officer here who was here on his day off. May I excuse him?
Absolutely.
Thank you, sir.
I'm sorry? No.
Do you want to do those pleas now, the inmates?
Yes, I think.
Well, the agreements just went back, Judge. I don't know if they've had sufficient time, so if you've got some privates or others that you can take, that'd be great.
Well, we've got all we've got are just those last, 4 or so inmates, but we do have got some other things that are 2:30 docket. Obviously, we're a half hour into that as well, so.
I can wait, Judge. I'd rather have them have plenty of time to read it and
Let's
not be
just go
rushed.
ahead and start with our 2:30 docket. Which one do we want to do first?
Yeah, Mr. Cromer, I know is gonna have a plea. I don't know if Mr. Morrow wants to do
Who's got the plea? Mr. Mitchell?
May I approach?
Well, if Mr. Mitchell's got a plea, he goes first.
I got all that.
You got a plea, you go first.
Oh, come on. That was Judge Brown's fault.
I plead ignorance again. It's my best memory.
Okay.
Judge Ketchel, we have defenses here. We were scheduled for a suppression hearing, but we think this is in our best interest. No contest.
Okay. Could you please announce this agreement? Did I take the only copy?
Yes, yes.
So I need you to announce it for me.
Once again, ignorance?
That's all right. No, it's just
Okay.
Different people do different procedures.
Fair enough.
No
I'm
big
Gene
deal.
Mitchell, and I've got terrible penmanship, and with
Yes.
regard to 20...
That's no reason why I have you read it, because I
Very good.
have a hard time reading it.
With regard to 20 CF 946, we're entering a plea as charged to count number 2. That's the felony charge, that's the weapons charge, for withhold of adjudication. With regard to count 1, we're entering a plea of no contest to a lesser included misdemeanor, which would be a 3rd DUI outside of 10 years. Part of this sentencing is going to include a victim impact panel, a multiple offender DUI school, a 1-year ignition interlock, 6 months driver's license suspension, 36 months probation, and Ms. Sharpless was kind enough to put in automatic termination at 24 months if he's in compliance. Credit for time served. He spent several months in jail already. And the state stipulates to the 30-day to credit for time served because he served in excess of 30 days before he bonded out. I think that is it. Is that right, Ms. Sharp?
The multi-offender DUI school, the 6-month driver's license, and the $1,000 fine.
Is that all in the plea
I
agreement?
did not write $1,000 fine, I'm sorry. Thank you for your patience.
Thank you. So, Ms. Sharpless, is that the agreement?
I'm sorry, Your Honor, we're checking to make sure it's not I think it might be a $2,000 fine instead of $1,000. I apologize to the court for that.
Okay, well, why don't you be checking on that while I engage Mr. Cromer in a colloquy. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
Okay, so I need to ask you a few questions. The purpose of these questions is really twofold, very simple. One, that you understand what you're agreeing to.
Yes, sir.
And that you're entering this plea agreement freely and voluntarily.
Yes,
okay?
sir.
So you heard your attorney state the terms of the plea agreement, and I see that those same terms, there's some question regarding the amount of the fine, whether it's $1,000 or $2,000. We'll get that.
It's $2,000, Judge, and I apologize. I am so sorry about that.
Okay, so we'll change that here in a second. Here, go ahead. So, like I say, you heard the terms of the plea agreement. They're contained in this written plea agreement that you have, make sure and confirm that, you have signed, correct? So, have you, first of all, read this sentence? It's called a sentence recommendation. It's really a sentence agreement. Have you read through this?
Yes,
Do you
sir.
understand it?
Yes, sir.
You have the chance to go over it in detail with your attorney to make sure you had all your legal questions answered.
I did.
Importantly, in this process, you're waiving some valuable legal rights to enter into this plea agreement. The legal rights you're waiving are, importantly, the right to go to a trial, the right to confront witnesses, the right to require the state to prove their case beyond every reasonable. Those are all valuable legal rights that you have in the U.S. Constitution that you're waiving in order to enter into this plea agreement.
Yes.
You understand that?
Yes, I do.
And you believe that's in your best interest to do that?
Definitely.
Okay. And you do, you have had a chance to go over this with your attorney and make sure you get your questions answered?
I have.
Okay. Very good.
And
Based upon that, the court will accept the plea and plea is charged to count 2, plea to lesser included count 1. There'll be a withhold of adjudication. It's to count 2. The core of this is the 36 months probation, as well as credit for time served, as well as the other specific requirements such as the victim impact panel and school, and etc. You will get credit for time served, and the fees and costs that are contained, they have to be paid during the 36 months. Yes, sir.
At the risk of being redundant.
No, sir. No redundancy here. We want to make sure that he understands. If you got any questions or want to raise anything, you're welcome to do that.
I'm directing my attention to the clerk. Count 2 is a withhold of adjudication. Count 1 is a misdemeanor.
It's an adjudication.
Adjudication for the misdemeanor, yes, ma'am.
They can't have 36 months probation.
1129 probation concurrent to 36 months on count 2 to 1129 probation on count 1. Concurrent with each other.
Thank you.
Yes, ma'am.
There's still going to be a 515 in court costs on the side.
Okay.
DUIs are in addition to.
Thank you.
Would 5:15 work?
And then offer early term option at 24 months.
It actually was automatically 24 is what she had suggested.
If I'll complete and know by this.
Of course. I'm really appreciative.
Oh, I forgot to write.
And I'm saying this mainly for the state because you guys are involved with more of them than the defense counsel. But I would just ask, I'm going to sound like I'm getting on you, I'm not.
I can take it.
We got to tighten up the writing because we're going to have somebody that's going to be complaining. We're going to be in some type of 3.850 fighting over what's the writing on these plea agreements. So we got to be clear on these. I think we're okay, but please be careful. Sure.
Gene Mitchell stipulates.
Mr. Cromer, I'll need your fingerprints.
So you're in agreement with the score sheet, counsel?
Yes.
And I know it takes a lot of effort to enter into these plea agreements and you're running around, so I do recognize that. I just
Mr.
want to
Cromer
make sure
has a
we're
question. He was hoping to move back to the state of Georgia. Do you have any perspective with regard to that?
There is you can often do that, but that's something that probation does. I know it costs $100 and they'll walk you through exactly what those requirements are. I'm not going to object to it, that's what I'm saying. I can't force it, but I think it probably can get done. But I don't want to, the judge said it again.
I understand.
It's the domain of probation. You want to add anything to that? If he wants to transfer probation to Georgia?
To Georgia?
Yeah.
He needs to have a $100 payment ready for when he comes to the probation office to pay the application fee. And are you a resident of the state of Georgia?
Not anymore.
Okay, so you have family there that you would be living with?
No, I live here.
Okay,
I'm so sorry.
then
You say you
that
wanted
would
to
be
go
a
back to Georgia?
discretionary transfer in that.
Never mind.
Okay.
Misunderstanding. Okay. Very good. Good luck.
Your Honor,
Mr. Morrow.
Mr. Ernest Powell, the sentencing hearing that we're about to begin
Yes,
on. I've received 2 more letters from family members today. The state was kind enough to agree to allow you to review it. Time they're much
To
shorter.
read them. You know, here we are at 3 o'clock on the day of.
I agree, Your
I
Honor.
mean, okay. Let's do Ms. Dudley's motion to dismiss. I think that's what we should do next.
I think the state had filed a motion to continue.
We did, Your Honor, and I apologize I didn't get in writing earlier. I intended for Officer Stenson, or Deputy Stenson, to come testify, and I found out late last week she's on military leave. I don't know, Ms. Dudley said she was objecting. We did have some communication just now in court. I don't know how she wants to proceed, if we want to hear the motion continue, or if she has any other information.
No, we just did a motion to continue.
I'm sorry?
So I guess we need to hear the motion to continue.
Okay. Hold on a second. Has it been filed?
I did file it, Your Honor.
The state may proceed with their motion.
Your Honor, I'm looking at the case law that Ms. Dudley has cited. I was intending to call Deputy Stinson to help flesh out some issues that I need to get fleshed out as far as dominion and control of the object and also the corpus delicti issue that Ms. Dudley raises. Again, Deputy Stinson's on military leave. She is not able to be here today. She is a necessary witness, and I have no problem putting this on the soonest available date if the court grants the continuance. This hearing has never been continued prior to this, Your Honor, so this would be the first continuance the state has requested.
Ms. Dudley.
Your Honor, defense objects. I believe it's a legal argument. Deputy Stinson did give a depo where she talks about the only basis for her charging him was the fact that he admitted.
I'm sorry, say that again?
She gave a deposition where she stated the basis for her charging him was the fact that he admitted to the firearm. And I believe the case law supports the motion. I believe it's a
You're
legal
saying that this witness is not necessary or even germane to the
That's
motion?
my argument, yes, sir. This case, we want to keep proceeding on this case. This case is holding Mr. Coward up from attending school, from being able to look at college opportunities. So we do object to a continuance.
So do you understand her argument? Would you respond to that?
And Your Honor, first of all, I would say that because we are going to be arguing about issues of deposition testimony, I do believe it's necessary to bring the deputy here. I do believe we will be able to flesh out some issues, and it would be imperative to the state's case for her to be here. This defendant is out of custody. There is no prejudice to his case being continued. One time for this hearing to be set at a different date.
I mean, as a general rule, something like this, I would be inclined to grant this. You've got military people all over here, and people can't be here. But I would like to at least get a response to Ms. Dudley's statement that this witness doesn't have anything to do with her primary argument that the charge is based solely on a confession, correct? That's your argument, right?
Yes, sir.
So what is the police officer going to do?
Your Honor, so if I were allowed to admit her testimony, I think it's important for the court to see that this gun was not within the reach of the backseat passenger. I think it's important for the court.
You're saying this charge is not based solely on his confession?
That's correct. I believe that the corpus delicti was established prior to his admission, Your Honor.
Okay, with that, I mean, I know there's disagreement. We'll have arguments about it. But based upon that, I don't want to call it a proffer, but explanation of what might be testified to, whatever inconvenience this delay would have would be minor, since that the defendant is out on bail. Why don't we try and get it rescheduled and see quickly as we can. Easier said than done, right? April 11th.
You've got 5 in the afternoon, you've got 55 on the plea day. I believe that Mr. Brown
Mr. Pate is a sentencing hearing. Micah Brown is also a motion to dismiss based on a traffic stop.
What do we have on April 18th?
5. We had 5 cases. The court was going to set one of mine earlier for that, and the clerk said there were 5 set, and that's where we had the end of the conversation.
I hate to lose a fire, but, you know, if y'all want to set these cases set up, as long as he's okay with it, the clerk certainly is.
Yeah, no, you're doing it my direction. You don't have to, please don't apologize. You just blame me. It's okay. What do we got on May 9th? May 9th.
2:30.
Your witness going to be here, I assume, by now.
I will either ensure that she'll be here in person or ask her to appear by video so that we will not have any more continuances.
May 9th.
Yeah, that's all I have.
Thank you.
Do you want to do this in quick, please?
We'll do it, please, whatever please are ready, we'll do it.
I will take out copies.
Judge, this is encroaching. It's Ronald Arthur Couch. His numbers on the docket today are 23 CF 249 and 23 CF 255. Mr. Couch also has another case that's set for next Tuesday. Case number for that is 23 CF 392. It's set for a felony plea day. All these cases are set for felony plea day. The informations have been filed in all 3 cases, and we have an agreement that covers all 3 cases.
Very good with you. Announce the plea, will you?
Yes, sir. Okay. The plea agreement is that he would be adjudicated guilty. There's 2 misdemeanor counts in 2 of the cases, and it'd be time served on those. There's a felony count in each case, and on the felony counts, he's going to be adjudicated guilty, be placed on 36 months probation on each count concurrent. Cost of supervision would be waived. He would pay court costs in each case, pay a $150 public defender fee in 23 CF 249, and pay a $100 public defender fee in 23 CF 255 and 23 CF 392. As a condition of probation, he would complete a substance abuse evaluation within 30 days of today and begin any recommended treatment within 60 days of today. He would complete a total of 50 hours community service work to cover all 3 cases, and he may buy out that 50 hours if he completes his substance abuse evaluation within the 30 days. His driver's license will be suspended for 6 months, and he has to get a job or submit 2 job applications per week, and he's also going to be subject to random urinalysis. If I can just briefly look at the score sheet here, Judge.
Is that the agreement of the state?
That is the agreement of the state, Your Honor, and I gave Mr. Russell the score sheet, and I believe he has it.
If I may approach you.
Very good. Mr. Couch, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
Okay, so you heard your attorney state the terms of the plea agreement, and I'm reviewing those terms that are contained in your plea agreement that you have signed. Have you had a chance to review this plea agreement? First of all, have you read it?
Yes, Your Honor.
And have you gone over it in detail with your attorney, make sure you have all your legal questions answered about it? You can put your hand down.
Yes, sir.
So you understand that by entering this plea agreement here today, you're waiving some valuable legal rights. Right to go to a trial, right to confront witnesses. Those are all constitutional rights that you're waiving so that you can get a final adjudication of this case. Is that what you want to do?
Yes, Your Honor.
Believe it's in your best interest?
Yes, Your Honor.
Okay. Nobody threatened or coerced you to get you to enter into this plea? Very good. Based upon that testimony, the court will accept your plea agreement here today as contained in the plea agreement, the core of which is the 36 months of probation on each count, each felony count in your 3 cases. You'll get credit for time served in the misdemeanor counts in all 2 of your cases. That you have misdemeanors. There's a number of fees and costs. Importantly, the substance abuse evaluation and treatment is critical. That's part of this, a condition of this probation. You understand that?
Yes, Your Honor.
You'll violate if you don't follow through with that. That's important. Okay. As well as the other fees and costs and the other things, including random UAs that are contained in this. So you need to immediately contact the probation office immediately upon your getting out. Okay, so first thing in the morning, if you can't get there today. Okay, any questions?
No, sir.
Good luck.
Jared Dawson.
Judge, this is Jarrett Lee Dawson. For the record, case number is 23 CF 212. Mr. Dawson has reached a plea agreement with the state. He's going to enter a plea of no contest to this case. The agreed upon sentence is that on the misdemeanor count, it would be an adjudication of guilt and time served. On the felony count, it would be an adjudication withheld, be placed on 24 months probation, waive the cost of supervision. He would pay court costs, $150 public defender fee, will complete a substance abuse evaluation within 30 days and begin any recommended treatment within 60 days. We have to complete 24 hours of community service, which he can buy out if he completes his substance abuse evaluation within the 30 days. He's to either get a job or submit 2 job applications per week. And I have a score sheet if I may approach.
Okay. Does the agreement state?
Yes, Your Honor, that is unanimous.
And is the defense okay with the score sheet?
No objection, no.
Very good. So, Mr. Dawson, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God? Yes, sir. So you heard your attorney state the terms of your plea agreement, and those terms are also contained in this written agreement that I see that you have signed. Have you, first of all, have you read this plea agreement closely?
Yes, sir.
And have you gone over it with your attorney in detail?
Yes, sir.
Had all your legal questions answered about it?
Yes, sir.
You understand that by entering into this plea agreement, it's the final resolution of this case. And you're waiving the right to go to a trial, and all the valuable legal rights that you have pertain to that. They had to prove their case, etc. You understand? Have you gone over all that with your attorney?
Yes, sir.
I believe it's in your best interest to enter into this plea agreement here today.
Yes, sir.
Any questions about it?
No, sir.
Okay, based upon that testimony, the court will accept your plea agreement here today, the core of which is the 24 months probation on the felony, credit for time served on the misdemeanor. There'll be an adjudication of guilt on the misdemeanor and a withhold on the felony. And also, importantly, is the substance abuse evaluation and treatment that have to be done directly, as well as some of the other requirements that are contained in the plea agreement. Okay, any questions? Thank you.
Nicholas Ducati.
I may have a moment, Judge. Judge, this is Nicholas Ducati. For the record, case number is 23 CF 261. We reached an agreement with the state in exchange for a plea of no contest as charged. On the two misdemeanor counts, counts 2 and 3, it would be an adjudication of guilt and time served. On count 1, it would be an adjudication of guilt, 120 days in the county jail concurrent. He would get credit for any time served. He would have to pay court costs, $150 public defender fee, and his driver's license would be suspended for 6 months. He would get 180 days after his release to pay, or the monies owed would be going to judgment. May I approach?
You may. Stated agreement?
That is the state's agreement here.
Defense okay with the score sheet?
No objection, Your Honor.
So, Mr. Ducati, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of the plea agreement. I see those same terms are contained in the written agreement that you have signed.
Yes, sir.
Have you read this plea agreement closely?
I sure did.
And have you gone over it in detail with your attorney, made sure you had all your legal questions answered?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving some valuable legal rights, the right to go to a trial, force the state to prove their case, etc.
Yes, sir.
And you believe this is in your best interest to enter into this plea agreement here today?
I do.
Nobody forced you or coerced you to get you to enter into this?
No, sir.
Based upon that testimony, the court will accept your plea. Agreement here today is to counts 2 and 3. There'll be an adjudication of guilt. You'll get credit for time served. Count 1, which is the felony, there'll be an adjudication of guilt. And you're sentenced to 120 days in the county jail. You will get credit for all time served. Court costs and driver's license suspension, etc. are all part of this. And you will have to pay within 180 days of release or it'll go to judgment.
Yes, sir.
Any questions?
Not at all. Thank you.
And Judge, all sentences are concurrent?
Yes, they are.
Thank you,
Right
Judge.
this way, Mr. Ducati. Ernest Powell.
Mr. Russell, could you come here for just a second?
Yes, sir.
As civil and or criminal defense lawyers.
Make sure he wasn't mad.
No, sir.
You done, Charlie? You done?
he's before the court for sentencing in 21 CF 2603 and 21 CF 493, 2 matters. The violation having been admitted, it looks back in December 15th. Mr. Medina.
Could you speak to that mic?
Is that better, Your Honor?
Better, thank you.
Do I need to back up a little bit?
No.
Okay.
Sorry.
He had pled to the bench with a 32.55 month DOC cap on prison, no cap on supervision, Your Honor. The state had previously stipulated the admissibility of 4 documents: the report from Dr. Zeman, 2 character letters from members of Mr. Powell's family, and then a letter of Mr. Powell himself to the court. So at this time, I'd ask the court to admit those as evidence as defense 1 through 4.
State, that objection?
Yeah, there's no objection to
That
that.
objection. Do you have copies for the clerk?
I do not, Your Honor.
Show those to me.
I'm sorry, Your Honor?
You gave me some.
I did.
You want me to turn those in?
If the court doesn't need them, after I can provide those to the clerk. I can provide them. That's no problem. I can get additional copies. I'm sorry, Madam Clerk.
We'll get them. I'll give them to you. Go ahead.
Defense 1 through 4. And has the court had an opportunity to review those documents in the time that was afforded?
I have.
Thank you, Your Honor. I think Mr. Powell would like to give some testimony, if that would be all right, Your Honor, so I put him under oath and take some testimony from Mr. Powell.
Please raise your right hand.
Yes, sir.
Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Powell, you're here for sentencing today in your BOP. You understand that?
Yes, sir.
Having admitted the violation. And you understand the court is in receipt of the letter that you've sent, so you know they have a general idea of your position, but what would you have the court know today before we proceed to sentencing?
I just want a few months ago you asked me why did I feel that it was best in my interest to enter this plea, you know, and I just wanted to...
Why that mic close to you?
Oh. I just wanted to, a few months ago you asked me why was this the best interest for me in this plea to admit my guilt, and I just wanted to accept the accountability, you know, for my actions. You know, I accept responsibility for my actions, but also at the same time, you know, I'm at the point in my life where I know I can do better and I want better. You know, I've been dealing with a lot of trouble in my past, you know, and that's a closed chapter, and I'm trying to begin a new story in my life. You know, I'm really at a point where, you know, I haven't been a man before, so it's just going and growing to becoming a man, and I'm really putting forth the best effort and taking the initiative to do what I need to do in life and become the person that I know I can be. You know, I have my children out there, I have my family out there as well. And, you know, I just know that I can do better. You know, I changed my life for the better. I have a strong, devoted relationship that I stand on, and I serve God with all my ability. You know, I'm a God-fearing man, and just want to let you know that I'm responsible as an adult, and I'm just trying to do the right thing. And trying to get my life back, and I don't want my freedom back. I've been going through this for quite a time, and, you know, I'm getting older in life, and I'm just trying to take the initiative to do what I need to do to become the man that I know I can become. And that's it.
And before we turn it over to the state, you recall sitting with Dr. Zeman in this evaluation, and you understand you have some mental health issues, that's right? And if a doctor was to recommend treatment for those mental health issues, would you follow that treatment?
Yeah, I was already...
Work on your mental health.
I was taking that initiative of getting out, like I already had it planned to. I want counseling, I'm going to go and seek therapy. I'm going to do all those things on my own, because I know taking this evaluation is showing me where the areas that I need to work on most in life. So I never acknowledged them before. I always try to handle things on my own, but knowing that I have a problem and want to take the steps that I need to take to get the help that I need.
So if a doctor recommends counseling, you will go to counseling.
Yes, sir.
And if the doctor recommends taking medication, you're going to take your medication.
Yes, sir.
All right, nothing further.
State?
Your Honor, the state has no witnesses, just argument when it's appropriate.
You wish to Do you have any other witnesses?
No,
sir?
I'm sorry.
Do you wish to make any closing remarks?
I'm going to make some remarks as to the evaluation, and that's it. So we have the report from Dr. Zeman. The evaluation is 9622. I'm reading from the summary and recommendations on the final page, Your Honor. And it indicates that the results of the evaluation do indicate the presence of active mental illness, including features of post-traumatic stress disorder and major depressive disorder with psychotic features. I'll skip down a few lines. In the final disposition of this case, the court may wish to consider as mitigation that Mr. Powell appears to meet criteria for mental disorder that requires specialized treatment and is unrelated to substance abuse or addiction for a physical disability, and he is amenable to treatment, and I think his testimony indicates that as well, Your Honor. Mr. Powell certainly could benefit, this is the final sentence in the recommendations, Mr. Powell certainly could benefit from a combination of individual and group therapy. He appears to have a long-standing history of untreated mental illness that, if properly addressed, could end his cycle of recidivism, Your Honor, and the defense agrees. And we believe that the character letters, Mr. Powell's testimony, Mr. Powell's letter to the court indicate that he is amenable to the treatment and that if he was given another chance, he'd give it his best effort, Your Honor. So we're asking the court to consider downward departing on that basis, modify the probation to any terms that the court deems appropriate in this case, and reinstate him.
Let me ask you just a procedural question. As it relates, you use the term downward departure. Does this require a downward departure to go below the minimum guidelines?
It would, Your Honor. His lowest permissible sentence is above 44 points. It would require a downward departure.
And was there a motion for a downward departure that was filed?
No, Your Honor. I've never filed a motion for a downward departure. I just present my grounds in a sentencing hearing.
Is downward departure not required to file a motion?
I've never filed one, and I've been
Doesn't matter
given
what you've ever filed, that's not the argument. It's not required, it's not required.
I'm unaware of any case that requires a motion for downward departure. Only the two-part process: can the court downward depart, and should the court?
Yeah, and the
That's
defense is
fine.
required to present evidence for the downward departure, obviously. It is sometimes done where a sentencing letter would be presented. However, I don't know if that was a requirement or that it's just a good idea to kind of guide the discussion about a downward departure, I think. But I don't know
So
that it's
because the
required.
language, which is interesting, the counselor would put the language of downward departure in his recommendations. But I believe that's the language, the criteria for a mental disorder requires specialized treatment is unrelated. Isn't that one of the downward departure?
It is, Your Honor, but it's my understanding that that was put in there because this evaluation was done for mitigation, which would require the doctor to make an opinion about whether the defendant has a mental disorder, which is amenable to treatment, I think. That's why this evaluation was completed.
That's all 100% accurate, Your Honor.
Okay, and then my second procedural question is somewhere on some of the VOP paperwork, perhaps, I don't know whether it's in the affidavit or whatever. It refers to the defendant as a violent felon offender of special concern. Is that correct?
That designation is correct. He does have a burglary charge, and he is on probation. A burglary charge is a qualifying offense. He is on probation, so he is a violent felony offender of special concern.
And does that affect what we're doing here today?
I don't believe so.
I don't believe so, Your Honor. I think it's important for the court to take into consideration. However, I don't think it affects the can you part of the downward departure.
I don't know, but I think the court actually has to make special written findings that he is not a violent person in order to downward depart. If that makes sense. And that's my understanding, is that when the court does a downward departure in a situation, he has to make special finding or writing that he doesn't qualify as a VFO. Not that he doesn't qualify, but that the court finds that he should when the president do something else. I think Ms. Bosso was agreeing with me over there that look.
Hold on just a second.
Nothing further from me, Your Honor.
So, Your Honor, again, as I stated, it definitely should be noted that Mr. Powell does have the violent felony offender special concern label. There is at least one prior burglary on the score sheet, at least one prior battery on the law enforcement, 2 prior felon in possession of a gun or a electric weapon. There's a fleeing and eluding on the score sheet. There are 2 felony batteries on this score sheet, Your Honor. All of those things do show that he does have a propensity for violence. This underlying charge for the VOP does give concern also, as it's a fleeing and eluding.
The VOP was, give me a little history of this case as far as was he on probation? Was it post-commitment probation? What probation did he violate, or was he put on probation for
in this particular
both the
instance,
underlying charges?
It was fleeing and eluding, Your Honor, was the underlying charge, and I am checking to.
I'm sorry.
I believe he was placed. The underlying is a fleeing and eluding. The felony 3 level 3 fleeing and eluding.
is the court asking what the VOP allegations are in this
No.
case? Okay.
I'm asking how he ended up on probation that he violated.
He also is on probation for possession of a controlled substance as well.
Right. So he was placed on probation. That wasn't a post-commitment probation. Because he served DOC time previously. He said it in his own letter. I'm trying to understand how this fits in to his record.
Okay.
I understand, Your Honor. He was placed on 2 years probation with the understanding that he would intend to complete the, as a special condition, Master's Forge. And I think at some point that was replaced with this program in Alabama called Fresh Start, so that he could attempt to get some help. Yes, because I did see an order modifying his probation from Master's Forge to the Fresh Start Recovery. The Fresh Start Recovery is part of the allegations of this violation, that he absconded and left that program. He was not able to be found after contact with family members, is the allegation of the VOP, and that there were some financials that were unpaid as well. Those are the basic allegations of this violation. And Your Honor, I think that goes back to the state's argument that he was given a chance. He is a violent felony offender of special concern. He did have a chance to go to treatment. It was his choice to leave that treatment in abscond supervision. They checked, the VOP report says that they checked with family members. He was unable to be found. Your Honor, it is concerning that, again, first of all, not only did he leave, but second of all, you know, they were unable to find him after contact with his most immediate family members, Your Honor. That gives the state concern that not only was he leaving treatment, he just thumbed his nose at supervision altogether, Your Honor.
How long was he at bay?
It looks like this violation was submitted in April of
3 months, Your Honor.
3 months. Yeah, April of 2022. It was submitted, and I think he was picked up in July.
I'm sorry, say that again?
This violation was submitted in April. He was picked up in July. So 3 months is accurate.
My client just wants the court to know that he had turned himself in on that, Your Honor.
I didn't leave because of I left the reason that I left the program because the treatment that they was giving me wasn't the treatment I needed, and I was going through what I was going through mentally. Like I was almost at a breakdown. So I took the time that I needed, and after I was able to be stable enough mentally, I turned myself in to accept whatever came behind the consequences for my action. So I did turn myself in. I did speak to my PO after leaving the program, and she told me that I should have spoke with her earlier, which I did, and my family could be witness of that. I called them a couple times prior to me doing what I did. She was supposed to be doing something on her behalf about the program. I let them know that it wasn't working. They was giving me treatment that I didn't need, and I did what I did. I came and I turned myself in, and here I am today. But I contacted her, I contacted my lawyer, I stayed in contact throughout the whole time what was going on. And before I turned myself in, I called her and let her know that I was going to turn myself in.
Your Honor, I did look at first appearance paperwork. On that paperwork, it shows the arrest information as 1200 James Lee Boulevard, which is the jail.
Okay.
Sorry, Your Honor. I will to finish the state's argument, Your Honor, with respect to that, I understand that he feels that way. However, he was given more opportunity than most people were. It appears that he himself and his lawyer chose this program specifically for him, Your Honor, so he is unable to even complete treatment that he chose for himself, Your Honor. And I think also it's important to note that while I stipulate to the doctor's evaluation, I think it's important to note that the issues that the doctor brings up were self-reported by Mr. Powell, Your Honor, and then that two-part test for a downward departure, even if the court finds that Mr. Powell is eligible for a downward departure, the second test is, should the court give him that downward departure? I don't believe the court should. Mr. Powell has had his chance to do treatment. He has previously been to prison, and being put on probation is especially after you've been to prison, is a privilege. His criminal history does show tendencies for violence, Your Honor. The state was willing to give him an opportunity at treatment, even though he's shown previous tendencies toward violence. I think that Mr. Powell has exercised all the second chances that Mr. Powell should get, and I would request that the court give him the guideline sentence under the guidelines cap under the sentencing guidelines, Your Honor.
Counsel.
Your Honor, I believe the court can and should downward depart in this case. I believe Mr. Powell is sincere in his desire to get away from the path that he's been on and break the chain of recidivism. I don't necessarily agree that he's a danger. I believe the court can find, based on the letters and his testimony, that he is not. So we would ask that the court consider modifying and reinstating probation with any terms that the court deems appropriate.
You got to try to help everybody. I don't have no try to do the right thing. Try to help everybody every way I can. I don't
Okay. The court's gonna reserve on my ruling on this. I need to look at a couple of things.
Understood, Judge, thank you.
I'm gonna make my decision a little bit later, okay?
We're ready for the Nelson here for last match.
I appreciate it.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview.
The four items.
Yes, Your Honor.
Be provided to the court.
I will, Your Honor.
They were admitted without
I
objection
understand.
by the state, but they.
I understand, Your Honor.
I'm not going to handle mine because I'm going to be looking.
I understand.
Or just an evaluation?
Just an evaluation. Okay, we're here in case number 22 CF 2308, is that correct?
Yes, Your Honor. No, it's 22, technically it's 23 CF 314 and 22 CF 2308, but I think the main complaint really is in the 22 CF case.
Okay. So, Mr. Jenkins, we're here on what's commonly called a Nelson inquiry. And so what I need to do is put you under oath, give you a chance, ask you a few questions that will give you an opportunity to explain what your position is. So would you raise your right hand, let me swear you in. Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so I understand you filed.
And Your Honor, just again earlier I mentioned, I want to make sure the record's clear. Part of the Nelson hearing requires Mr. Jenkins to waive the attorney-client privilege because he's alleging that I'm ineffective. I want to make sure that he understands that that means I have the right to disclose what he and I talked about that would normally be privileged in order to defend myself from the allegations.
You understand that, Mr. Jenkins?
Yes, sir.
Okay, so he may be talking about some things that normally he's using the term privilege. That's a legal term, but basically private communications that are kind of, we always hold those, sacrosanct. They can't get at those. So you talk to your lawyer, that's between you and him and him, but that's not gonna be present in this case. Do you understand that?
Yes, sir.
Okay. Anything else, Mr. Gates, before I begin?
No, Your Honor, not anything else.
Did I swear you in?
Yes, sir.
It's been a long day. Mr. Jenkins, first I need to ask you, make sure to be clear. that you're asking the court, or are you asking the court to discharge your attorney?
Yes, sir.
Okay. And so what I need to do is just ask you an open-ended question of why you wish to discharge the attorney, and the reasons why. And I know you wrote a letter, but I need you to summarize it. I've read this.
I feel like if I move further with my attorney and I'm looking to fight in this case, it's not going to happen with him. There's no fight in him.
So what has he done wrong?
For instance,
I'm sorry?
Like for instance, there's a motion, he filed a motion to suppress on my end. Like, but you never did depositions with the officers to even get this information to do a motion to suppress. And then in your motion to suppress, you're putting case laws that's been overruled, that's no longer no good, and you're already telling me that the court's gonna deny them. Then we're arguing. I don't think I should be having no dispute with my attorney, someone I'm putting my life and freedom in his hands. And then I can keep going on like everything, evidence I don't, from the video cam and all that, I paid myself personally out of my pocket, gave it to my attorney. He has not even reviewed the cams to even fight the case, so how did you do a motion to suppress if you had never even reviewed the body cam? So what motion are you filing on? I mean, everything I'm sitting here trying to give him all the rights to move forward with, I mean, he's failing me on. I had my own motion to suppress. He wouldn't even move forward with that. He wanted to move forward with his. And then he's telling me straight up, his gonna get denied. And we're gonna have to fight it with an appeal. It had never even reached your hands yet. And there's already a decision made on it. It's kind of scary.
So the two areas that I hear you, two reasons. One surrounds the motion to suppress. The fact that you don't believe he adequately prepared for it, and that somehow he didn't fight hard enough or appropriately enough on the motion to suppress. That's number one, right?
Yes, sir.
And then the second thing is what I would characterize as just kind of general lack of preparation, and you pointed to one issue that he wouldn't obtain the video cams and that you had to pay for the video cams, and then you said even when you got the video cams, I assume these are video cams from the police.
Yes, sir.
That the council never reviewed them. That's what you're complaining about?
Yes, sir.
Okay. Any other specifics of things that you think he either did or did not do that were ineffective?
And like, even between us, like, the understanding that him and I should have, it's not there. Like, he's an attorney. I don't expect you to, like, be my best of friend. I just expect you to just do your job, I put my trust in you. There's no way I can put my trust in you. And then you kind of, even at the jail, they had to pull me to the captain's office to ask me was I all right, because it looked like I was being attacked by my attorney. I don't think that's kind of right, And this motion, you got a motion to suppress. I don't see how you can do a motion to suppress if you have not did the deposition or even reviewed the body cams. What grounds, and then the grounds you're using, they've been overruled. They're no good. So I know my motion is going to get denied because he's telling me. So if I appeal it, I'm
You're
set.
saying the cases that he used in his motion to suppress have previously been overruled and are not good law?
Yes, sir.
How did you come to that conclusion?
It's in the law library. I reviewed it. He also gave me the cases himself. He gave me copies of them. So I gave him a copy of my motion to suppress, but he returned it back to me. It was right here, but he wouldn't use mine. I had no choice but to go with his.
So I assume you have some legal training?
I mean, you got in trouble because you gotta have a little understanding of something.
Some. Okay. Anything else?
Other than that, I'd just be babbling and babbling.
Mr. Gates, what is your response to these allegations of ineffective counsel?
Does the court want to put me under oath first before I respond?
Would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor, I do.
And would you please speak into that mic for me so I can hear you well?
Yes, Your Honor. And when I reviewed his motion, I actually had what I felt like was 8 different grounds that he had listed in his motion. And then today, at the testimony, it was less than that. So I'm hesitant to get into some of his motion because I feel like part of it deals with the motion to suppress that he once filed. And I feel I shouldn't get adversarial with him about his motion to suppress on the record. You know, so I'm going to try and just, towards the end of like the second to third page, I think he gets more into a motion to suppress that he feels that should be filed. And I don't really want to, I feel like if I get into that area of it, it'll be more adversarial, and I don't really feel like that would be comfortable with the record, Your Honor. So I'm going to try and just stick with the other parts. I know one of the issues he talked about was the body camera. I will tell the court, in all honesty, he did. He reached out to me pretty early on, asking if I had the body camera. At that time, I hadn't. We had requested the discovery from the state, but sometimes it takes weeks. And he had mentioned that he could go down and order it and pay for it himself and then provide it to me. I said, that's great. If you want to do that, I'll be more than willing to take it. I'll review it. I'll look at it. He did that, brought it in. I'm not sure why he says that I hadn't reviewed it. I have reviewed it. I've reviewed all of the body camera. Now, I will tell the court, when I did the depositions, I reviewed what I felt was necessary to do the depositions. Going into this case, Mr. Jenkins had a very specific trial strategy that he wanted to adopt, coupled with a very specific motion to suppress. And my view of the evidence was a bit different. I felt that the trial strategy he wanted, his motion to suppress, wasn't appropriate, and we needed to go a different route. And so, reviewing the body camera, I looked at what I needed to justify or make my argument for the motion to suppress. After reviewing the body camera, doing the depositions, I went out and spoke with Mr. Jenkins, and he brought up another issue. And I said, well, I didn't see that in the body camera. I apologize. I'll go back and review it. Subsequently, I've reviewed every bit of body camera that we have, every second of it, all 5 videos, 40 minutes or so each video. As far as the depositions are concerned, I know in his motion he had mentioned that I canceled the deposition of Officer Trujillo. It was actually Officer Mooney. Mr. Rogers was there with me. During the deposition, it became apparent, in my opinion, that Officer Mooney was not prepared. He had not reviewed his body camera, and most of the answers I got was, I don't recall. At that point, I canceled that deposition and was able, with Mr. Rogers, able to reschedule for the following week. At that point, I did the deposition of both Officer Mooney and Officer Trujillo. I then went back out to the jail, and that's when I discussed it with Mr. Jenkins. The issue I have, and the court's aware of this, ethically I'm obligated to file motions that I feel aren't frivolous or in bad faith, which means sometimes that we have to tell clients, we're not going to follow your motion, I'm not going to adopt your motion. And that's what I told Mr. Jenkins, I'm not going to adopt the motion, I feel like it's in bad faith. He is talking about my motion to suppress. And my office has kind of taken a look at the issue, which is the odor of marijuana search, coupled with the medical marijuana card, which is what Mr. Jenkins has. And right now, Johnson v. State, it's the first DCA case, clearly states that the officer has the right to search the vehicle based upon the odor of marijuana. It even discusses the potential issues with medical marijuana. We have decided as an office to try to fight that, because there is a concurrent opinion in another case where Judge, I think it's Bill Bree, basically says, we really should reevaluate this given where we are with the medical marijuana and hemp. And so that's what I suggested to Mr. Jenkins, was that, look, case law is not on our side, but we have every right to come in and challenge it and say, it's wrong, it needs to be reevaluated. This is a very specific case, and we think this is a case where we should have the option to have our motion granted. My expectation was that the court would likely grant it. That's my experience, or deny it based on my experience of training. I've been doing this for almost 14 years. I kind of know how the court reacts to these types of motions. But that doesn't mean that I wouldn't file it and I wouldn't make the argument. For years, the defense bar filed ring motions in death penalty cases and continuously got denied until ring became an actual issue. In every case that we had ring filed in, was able to come back on review. And that's what I tried to explain to Mr. Jenkins, was that I think that given the specifics of this case, we had a good argument for the court to consider. And if the court denied that motion, it would get a chance for the appellate court to take a look at it, determine whether or not it needed to be reviewed. That was what I was suggesting to him. Now, part of this motion does address the speedy trial issue, Your Honor. That's a trial strategy decision. He and I had talked about that. When I first came onto the case, he was adamant he wanted to do a trial. I discussed with him the options and the way that I typically handle a case is I like to do depositions, I like to be prepared for trial. The day before I filed the motion to continue, the first motion to continue, I actually spoke with him and discussed the fact that the state had agreed at that time to return his cell phone without receipts. Mr. Jenkins was ecstatic. I explained, okay, so I'd like to continue the case so I could do the depositions in the case and look at schedule of motion, and he was more than willing to agree to it. We waived his appearance, filed the motion, and it was continued. I would point out that the bar is very kind of clear on this. It is a trial strategy decision. It's up to the attorney to make that decision. And I'll cite Boyd v. State, which is 45 Southern 3rd 557, and then Williams v. State 385 7 2nd 722. And essentially, it's a strategic decision. One, the client has to understand if I'm not prepared for trial, he actually has to waive his claim to ineffective assistance. That's first hurdle. He has to be able to come on the record and say, look, I get it, my attorney's not ready, I want to go to trial anyway. If I'm found guilty, I can't hold him ineffective because he's telling me I'm not ready. Second part, I have to believe it's in his best interest. Given what he's charged with, I did not feel that it was in his best interest. Therefore, I chose as a trial strategy decision to continue the case. There is the second speedy trial, which under the court's well aware of which we could demand speedy trial. At that point, it would put us in a position where we can no longer file any sort of motions. We are ready for trial right then and there. And it precludes us from filing any motion, whether it be his or mine. Again, I'm not prepared to do that given where we are with this case. He put in his motion the failure to file the motion to suppress equals a 3850. I would point to the case that is cited, which is Nunez v. State, and in that one, it's actually a secondary ruling on post-conviction relief. In other words, did file the motion to suppress, went to trial, lost, post-conviction motion, denied, then back up on appeal. And at that point, the DCA said, look, we need more to figure out why the motion wasn't filed. There's not enough on the record to make that determination. It doesn't apply all here. We're having on the trial. This isn't a post-conviction motion, so I don't think him saying that I'm ineffective for failing to file the motion to suppress is adequate either. We mentioned the transcripts as well, Your Honor, and I did review the case law, and I talked with my supervisor about this issue. And our policy based upon the case law is if we have the transcripts in hand, if I've ordered the transcripts and they're in the file, we give them a copy. No hand, no fee, no nothing. And I was wrong, and I'm telling the court, I told Mr. Jenkins he would need to pay for that. That was my understanding. When I asked my supervisor, he said, no, based upon case law, they have a free copy. Only if we have them transcribed. If they're not transcribed, then we don't pay for a copy just to have a copy for him. It's a trial strategy decision, again, whether or not I wear a transcript. I haven't decided to do that. What I did offer Mr. Jenkins was the opportunity for me and him to sit down to listen to the depositions so that he and I could figure out what was said. And I even told him that I would be willing to tell him, I even told him what we talked about at the deposition. And I said I would be willing to come back and talk to you and let you listen to him. But I at this point, because I don't have a copy, I can give it to him, and I don't think he's entitled to it based upon the case law. But I also say the case law specifically states a special assistant public defender. I like to think I'm a special assistant public defender, but I don't think I qualify in the way that that case law discusses. Depositions, again, a trial strategy decision. He mentioned also an incident where I guess they pulled him in asking if I was attacking him. I don't recall that, Your Honor. I do know there was an incident during one of our interviews where Officer Tarver at the jail was sitting outside our room. She was there because another attorney was meeting with a MAC client. During the conversation, Mr. Jenkins got kind of animated, stood up, and was kind of pacing back and forth. At that point, Officer Tarver opened the door and said, "You need to calm down or I'm going to end the interview." At that point, Mr. Jenkins did sit down. We were able to continue the interview. I think I would have been contacted by somebody at the jail, especially Captain McDaniel, who was captain at the jail, would have contacted me if there was an incident or an issue with my attorney-client meeting. I haven't had anyone reach out to me, Your Honor. I've been back to the jail multiple times. And if I can, Your Honor, to me, this all boils down to, and I want to read something that I've gotten from the Florida Bar before, Your Honor. A lawyer has a duty to exercise independent professional judgment and render candid advice. In giving advice, a lawyer has to be straightforward and honest, and the advice may not be what the defendant wants to hear. It oftentimes may involve critical assessment of all alternatives available and unpleasant facts that you may not want to confront. There may be occasions, and the lawyer may make a decision that is in the client's best interest. A lawyer must act in the client's best interest, and on occasion there will be disagreement. The client always has the ultimate decision on whether to enter a plea, whether to waive a jury trial, and whether he or she will testify. Questions of trial strategy and tactics rest with the defense counsel after consultation with the client, and he cites some cases, including what trial should be, or what trial motions should be made, and which witnesses should be called. The decision to demand a speedy trial is also a decision that is a tactical matter. When the accused asks for speedy trial, he or she is bound by the demand. Once the demand is filed, it is considered to mean that the accused has diligently investigated the case and is prepared or will be prepared for trial within 5 days. What we have here, Your Honor, it boils down to butting heads. I'm trying to tell him, based upon my training experience and my understanding of the case law, where we need to go and what we need to do. Mr. Jenkins has his own very distinct trial strategy and pretrial motions he wants to file. I am under no obligation to file his motions or to adopt his trial strategy. Florida Bar is very clear on that. At no point have I done anything in this case that would be considered ineffective. And in fact, I think at every point in this case, I've been ethical and professional with Mr. Jenkins.
Let me just ask one other issue that was, he didn't cite any of the cases. He said that a number of, I think he used the plural term, cases that you cite in your motion to suppress have been overruled.
No, Your Honor, they haven't been overruled. What I gave him was the litany of cases. One, I gave him the exact same copy of Johnson v. State. The state gave me after our deposition, stating that the odor of marijuana is sufficient to search a vehicle. I said there's a litany of other cases out there from other districts, other DCAs, that very clearly say the same thing. Odor of marijuana is sufficient to search the vehicle. They all address the potential issue with the medical marijuana exception, and that's where I told him that's where I think our best argument lies. The motion suppressed that
he is wanting to argue really deals more with the traffic stop as well as what occurred after that. And to me, that's a bad faith motion, and I'm not willing to adopt that.
Mr. Jenkins, you may respond if you wish.
Sir, I just can't see myself fighting my help.
I'm sorry?
I can't see myself fighting my help. If he's so sufficient like he said, I don't see myself going against and like arguing against something he's trying to help me win. There's no win. He told me straight up that his motion, not because of what the motion is going to get denied because what he found in the, if I'm not mistaken, it's like Johnson versus something, and it's been overruled. It was before a marijuana card was issued. It's not about a smell of marijuana. It's the purpose of what they went through the route of, and this case has nothing to do really with my case, and he used it for my case on a motion to suppress. Now then we go to, he stated Miss Tarver never came. We have videotapes up there. It never came. She never came and asked me to do nothing and checked in.
You're now arguing why you think your motion to suppress is superior.
Now, my motion suppressed right here, he can speak for itself. Now, I asked him if we could present this. He straight up told me no, because his motion, which is he was going through, which I understand, he has a job and this and that, but we couldn't. I said, well, why can't we make an agreement? This is where our whole total disagreement came in about a motion to suppress. His grounds, he used like 3 grounds, and once again, if you review the grounds he used, they're no good. These motions, they're been batted down in the Supreme Court. So why would I use these motions that's been batted down on a case that has nothing even according to mine to fight for? And he's stating to me off rip that this motion is going to be denied and I'm going to have to appeal it.
I mean, he explained to the court very clearly why he thought it was going to be denied and why he was willing to proceed forward with it in an effort to over-appeal it on appeal. He said it very clearly. He agreed with you.
Yes.
He said it probably would be denied because of the past case law. See, we have to follow, as the trial court, we have to follow.
Yes, sir.
We have to follow whatever the appellates are saying this is the way it is, but the appellates can change their mind.
But see, and I found the same thing that he could have did in state laws have shown.
You're just disagreeing with him on the law. So, you need to understand. So I'm just telling him, I'm teeing this up. There are a few areas that you have an absolute right to make the decision. Okay? Whether to testify. Those are the points he made. Whether to give up your right to a jury trial. Right? What were the other ones that the right to...
Whether or not he'll testify at trial, Your Honor.
Right to testify at trial. Those are your right. He can't tell you, look, you need to testify at trial or you should never testify. He can recommend to you, but that is your call. But there's a lot of other issues that's his call. Okay? That's just the way the law is set up. Basically, they're saying it this way. Be honest with you, they're saying, look, he's the lawyer. This is not a lawyer. You need to, when it comes to strategy, we're going to defer to the lawyer.
That's why we do.
So listen to me. I'm following up with saying, so I don't believe there's a basis for, because I have to make a finding that his lawyer is incompetent. Okay? Now, you have a right to fire your attorney. You understand that?
Yes, sir.
You have the right. But if you do fire your attorney, and I don't find that he's incompetent, I'm not going to appoint you another one. You can go hire one. You can hire one. You have the right to do that. So, but here's the thing. I don't find that you've set forth a case that what he has done is incompetent. I see you disagree with him on the motion to suppress. But that doesn't equate to incompetence. It's just, you all have a disagreement. And you hear what he has to say, because all the lawyers in the room understand what he was saying. But I want you to understand, you may not fully appreciate this. He has an obligation when he files not to file something frivolous. You know what could happen to him? If he files something that he knows is not right, you know what could happen to him? They could disbar him. Okay? So all the lawyers understand that. And so, quite frankly, if he thinks that this is not right, he's not going to do it. And if you fire him, that's okay. He don't care, because he'd rather you fire him and he can keep his profession rather than losing his law license. Okay? So again, I'm not making a definitive ruling saying he's right about this motion to suppress and you're wrong. You're going to tell me what I know right now. I'm kind of leaning one way or another right now, but that's not the deal. It doesn't matter whether, even if your approach is superior, because he has the right to make strategy calls. Okay, so my ruling is I'm not finding him to be incompetent. So now the ball's in your court. Do you want to fire him? You fire him, you're on your own. You can hire somebody, you can go pro se.
I still stand if I had no choice. Because
you got a choice.
I would ask you, this is what I would ask you, Your Honor.
Look, I made my ruling, I listened to you, I listened to you openly, and you have a right to either proceed or not fire counsel.
Your Honor, I may make this a little easier. My concern is, given some of the statements Mr. Jenkins made today on the record, I think that at this point, the court would probably be better off finding a conflict between the two of us and letting him have RCC. I just, based upon the statements today, and I don't want to get into more than that. I think it rises to the level where the court probably should certify the conflict to let him have a new attorney out of an abundance of caution.
There you go. You're making a whole motion to withdraw.
Yes, Your Honor.
On what you believe is a possible conflict with your attorney.
Yes, Your Honor.
Okay. Very good. I'll grant your request and appoint the regional conflict counsel.
I'll follow up with an order tomorrow, Your Honor.
Very good. That okay? Thank you. That's a wrap for today.
I didn't know if you were going to call Mr. Powell back out today, Your Honor.
No, I'm not going to call him. I'm going to reserve for today, but I'm not going to drag my feet on it.
I understand. I just wanted to know when to be back for you, Your Honor.
Yeah, that's a good question.
Could we do next week?
Yeah, we'll do it next week.
Just
Okay,
leave it
we'll
as
set
a
it
status.
for March 21st.
I'll be there, Your Honor. Thank you.
That's fine with the state too, Your Honor.
Is that going to be in the afternoon?
Yeah, it'll be in the afternoon. We'll just do it.